Good day from the United States of America. Uh, my name is lawyer Dr. Janet Fashakin, and I am the CEO of the law firm of Fashakin and Associates PC. We are located here in New York, and we focus on simple and complex immigration matters. And we do practice other law matters like foreclosure, divorce, landlord and tenant. But our major work is on immigration, and we have been in practice since 2001. You can't believe that, and that's 23 years from the same location, just bigger, and that is at 10522 Jamaica Avenue in Richmond Hill, New York, Queens. And we welcome you to call us. Our office number is 718-441-6056. And our WhatsApp number is 646-261-6030. Uh, this morning, I want to talk about filing for your family member, and who can file, who can you not file for. And particularly, I'm going to touch on after your petition is approved, is that the end of it? Or do you still have some steps to take because before your family member can have immigration relief and be able to get a green card? I've seen people coming to me say their petition was approved and it's been approved for, like, one was 3 years, one was almost 6 years or 7 years, and was waiting for the immigration to do something, give him something. And I said, this is a relative petition approval. You still have some steps to take. And rather than talk to an attorney for the last 7 years, you believe that the immigration is going to do something and give you a green card. That's not the way it works. And that is why I will urge those who are filing immigration. Sometimes people will file it and they will go through without an attorney, but it's worth using an attorney for, because some people have filed for themselves and they met themselves in deportation proceeding for something that they didn't do or that they did that they should not have done. I liken it to somebody who wants to build a beautiful house. He's not a bricklayer, he's not a painter, and he just said, "Oh, I can do it. I've watched them do it." You may be able to build it, right? But on a stormy day, you will know a qualified bricklayer from an impersonator. And that's what happens when you have cases like this. Um, Talk to an immigration attorney. And if you don't know who to talk to, we are here. We are an immigration attorney, and we have been in practice for 23 years. We thank God for what we have been doing to help many people. You may not be able to help everybody, but certainly if you are able to help at least 90% of those who come to you, you have tried. You may have a 10% that have destroyed their cases before they come to you. Even if they destroy it, we are still able to assist because we are also not just immigration attorney, we are also appeal attorneys. We can appeal your case, and many times when the case gets to appeal, it gets overturned, and you can then get what you've been looking for. Right. Again, my name is Janet Fashakin, and I'm an immigration attorney. We deal with simple and complex immigration cases. Uh, Today, I want to talk to you about what we call I-130. I-130. Uh, what is that, and what do we use the form for? By filing Form 130 and providing the supporting documentation, You clearly show your plan to sponsor an immigrant family member and signal your understanding of the financial commitment involved. When you submit the I-130 petition to USCIS, USCIS is United States Citizenship and Immigration Services. That's the first step to getting a family-based green card. It proves that you have a real family relationship with the person you are sponsoring for a green card, and it shows you are willing to support them financially if they are approved. This is especially important when getting a marriage-based green card. It shows your marriage is real and not just a way to get a green card. Immigration will regularly scrutinize your application to make sure you are not filing for somebody who just paid you and who you may not be related to. So they might send you, they might invite you for an interview, and many things that I've seen. If they invite you for an interview, they ask you basic questions that those who are really husband and wife will know. Okay, they might ask you what did you eat last night? Who woke up first this morning? Uh, what is the color of the curtain in your bathroom? And other things. If you have never been to the house, you will not know. They will ask you, and they will ask your petition. They will ask your beneficiary, and once they are convinced that you guys are really related in the right way, that will be the first step, and they will approve it. And once approved, that's not the end of it. Like I said, when we put in the paper for husband and wife, we immediately put in the paper also for the beneficiary to adjust his or her status. And usually that is what is missing. People get approved I-130 and they are carrying the approval around. I have been approved. I have been approved. But they never took the next step to adjust their status to be able to get a green card. Next time I will talk about adjustment of status. But today, I just want to focus on I-130, and I do want to send out the message. If you have an approved I-130 and you don't know what to do next, please talk to an immigration attorney. Don't begin to carry it around because it does not give your beneficiary any status immigration-wise. He or she has to take a further step to get the benefit that is due from a family member that filed an immigration petition uh, for the person. Filing the I-130 petition also establishes your place in line for an available green card, unless you are the spouse, parent, or married child under the age of 21 of a US citizen who gets to skip the line entirely. They don't, their visa is ready, so it's not something that they have to wait. Unless you belong to grad category, your place in line is determined by your priority date, which is the date that USCIS received your I-130 petition. Typically, petitions are processed in the order they are filed. Okay, you can check the visa bulletin online. You can type visa bulletin, it takes you there, and then you'll be able to learn about the current waiting period. Somebody will ask, how much does I-130 cost? From April 1st of this year, the price of immigration petitions have gone up. The I-130 that used to be, I think, 530 is now way over 600. It's now 675. And you have to be sure that you submit the exact amount of the filing fee. If it is $1 more, your petition will be returned. If it is $1 less, it will be returned. So always check to confirm the filing fee before you file. And you can also call the customer service. They will tell you. If you are sponsoring more than one person, make sure you don't put everything inside the same packet. Otherwise, whatever documents you put in there can be used for one person, and the other filing may be that there was no supporting documents, and it can be rejected, it can be denied, it can be returned. All right. So all these things they matter with timing. Somebody will say, "I filed this last year," but it's not going to be telling you that along the line that the petition was returned for something that was missing. Sometimes it is the check that is missing. Sometimes it is the marriage certificate that can show that you guys have a relative relationship that gives you that immediate benefit. So if you're going to be doing it for yourself, make sure you sit down and you spend time on it. And time is money. The time you are wasting, you can give it to somebody whose job it is to do it, and they will do a good job for you. A US citizen waiting time is different from a green card holder waiting time. When both of them file for people, it's usually faster with US citizen than with green card. And there are some categories of people that green card holders cannot file for, that a US citizen can file for. Next time when I come your way, we also discuss that. This day I've brought you I-130, especially those who have an approved I-130, who believe that with that approved I-130, immigration will not be able to deport them. Yes, they can deport you because you don't have any status yet. Okay, you don't have any status yet. It might ameliorate the situation to know that you have filed for something, but you need to take a step further. Now, who cannot file for my 130? There are some eligibility exclusions that prevent the filing of an I-130 petition, even when there is a family relationship. You cannot file an I-130 in order to sponsor the following relatives of yours: your grandparent, your grandchild, your nephew, your niece, your uncle, your aunt, your cousin, or parent-in-law. An adoptive parent or adopted child if the child was adopted after he or she turned 16 years of age. That is the aging out for the sake of immigration. However, there are people you can file for, and I can say it's unlimited depending on the relationship that you have. You can file for your biological parent if you became a green card holder or obtained US citizenship through, what am I saying? You can file for your biological parent, yeah. And you can also file uh, for your adoptive. Did I say adoptive parent? No, you can file for your biological parent. You can file also for your spouse, husband and wife. And those that you cannot file for is what I was going to tell you. You cannot file for your adoptive parent or adopted child if the child was adopted after he or she turned 16 years of age. Your biological parent, if you became a green card holder, obtain US citizenship through adoption, you cannot file for your biological parent. Why? Because they have adopted you out. They are no longer your parents in the right definitions of it. Your adoptive parent is now your parent. So your biological parent is removed from those that you can file for. And I see that some biological parents, they allow others to adopt their children, believing that they can come back to file for them when they get to the age in which they can do that. No. You cannot also file for your step parent or stepchild if the marriage that created the step relationship happened after the child turned 18 years of age. Now, a spouse, if you and your spouse were not both physically present at the marriage ceremony, like this arranged, not necessarily arranged, but this marriage by post, or a marriage in which they will do it for you, because you are not able to come to attend the ceremony, you will not be able to file for each other. A spouse, if you became a green card holder through a prior marriage to a US citizen or green card holder, unless you are now a naturalized US citizen or have been a green card holder for at least 5 years, you cannot file for a spouse if you marry your spouse while he or she was part of any immigration court proceedings, a hearing in an immigration court for someone facing deportation, or more formally in a removal proceeding. Uh, it doesn't mean you cannot marry the person, but you can just not file for the person. If you do, they will not approve it. You can't just file for any relative. If USCIS has determined that this person married or attempted to marry purely for immigration purposes. So you have the do's and the don't. As easy as I-130 is, it is important to know that there are exceptions to some of those exclusions, and that you may be able to file a 130 with additional supporting documentation in those situations. The I-130 petition must be filed with supporting documents to prove that the sponsor is allowed to file an I-130 and that they have a valid family relationship with the person that is seeking a green card. So, uh, what are the required supporting documents that you need? You have to prove that the sponsor is a US citizen or a green card holder. You have to prove that a legally valid relationship exists between you and the person who is sponsoring you. You have to prove that the relationship is not fraudulent. And you have to prove of name changes for the sponsor or the person seeking a green card, if any, and then proof of nationality of the person that is seeking a green card. He must have a place that he can call his country. You'll be so surprised how many people don't have countries. Maybe because they've committed something, they ran away from their country. They can come over here. I don't know why that may be difficult, because those who claim asylum, they ran from something, and then they are still able to. Uh, all right. I hope you have benefited from this lecture. And if you have a question, you can call. You can WhatsApp me 646-261-6030. You can also email me at janetfash@gmail.com or fashlawpc@yahoo.com. It may be better to use my personal one so that it comes directly to me and I can address your concern directly. Uh, until I come your way again, I say stay peaceful, stay above board. And like the logo for our office, I don't know if you can see it. It says talk to us before they talk to you. Visit us before they pay you a visit. All right? We are the ones you need uh, to talk to before they begin to talk to you. And we are the ones you need to visit before they come visiting you, which may not be palatable. Thank you very much. It's been a great time coming your way again. And until another time, thank you and God bless you.